Hello everyone. The presentation would be on the topic uh, the alternate dispute resolution. So India, our country has a vast number of cases recorded and also many of them remain pending. So in order to deal with the remaining pendency of cases, our government has brought up an alternative option of resolution into the picture. ADIA, which is the introduces a neutral third party, which helps the parties to communicate, discuss the differences, and resolve the dispute. There are basically four types of resolution system in alternative resolution system in India: arbitration, conciliation, mediation, and Lok Adalat. Negotiation is something which is self-counseling between the parties to resolve the dispute, but it doesn't have any statutory recognition in India. But there are certain provisions, such as Section 89 of the CPC, which provides the opportunity to the people, if it appears to court there exist elements of settlement other than the court. The act Also, the act with there is an act which deals with the alternative dispute resolution under the Arbitration and Conciliation Act and the Legal Services Authority Act. Also, the ADR has several benefits, such as it is less time consuming, as the court proceedings could be very long and dreadful. It is a cost-effective method. There is no involvement of the court fees as such in this ADR method. Also, there can be a use of informal ways to resolve a dispute rather than the use of formal language. The parties are free to express any facts and figures in the mediation or arbitration process which is not seen in the regular court proceedings, and the parties can restore relationships and can preserve the best interests of the parties. So the arbitration method is cannot is something which cannot be valid without the prior agreement to the emergence of the dispute. The prime objective of arbitration is to obtain fair settlement of dispute outside of the court without the necessary delay and expense. Second method is mediation. It involves the third party, neutral party, which aims to assist two or more disputants in reaching the agreement. It is an easy and complicated method where third party acts as a mediator to resolve the dispute by using the appropriate communication and negotiation techniques. The mediator's work is just to facilitate the settlement of their disputes. The third method is conciliation, which is less formal than arbitration. It is a arbitration method, but there is no need of prior agreement and cannot be forced on party who is not intending for conciliation. This is the difference between the conciliation and arbitration. Uh, Here the parties meet separately and not at the same time with the conciliator, which lowers the tension between the parties, improves the communication, and interprets the issues to bring the negotiated settlement. The fourth is the Lok Adalat, which is the People's Court, presided over and can be seated by the retired judicial officer, social activist, or member of the legal profession as a chairman. Any case pending in the regular court of law can be referred in the Lok Adalat, but there is no court fees and rigid procedure followed here, which makes the process even faster. If any matter pending in court is referred to Lok Adalat and is settled subsequently, the court fee originally paid in the court when the petition is refunded back to the parties. So these are the options available in the ADR system. And my question is that Should ADR be legally binded or have statutory recognition in India? As we know, it doesn't have any statutory recognition in India yet. So my opinion is that no, can't get a legal recognition as it is bound to solve the person conflicts, and it might not take any law into the consideration. It is also it is not the best option in the cases of fraud, mental or physical harassment, violence, etc. Thank you.